Hi, this is Kowski for AP Gov, and in this video we're going to be looking at the Second Amendment in a very important case in 2010 known as McDonald v. Chicago. So some background, of course, you might be familiar with the Second Amendment, and this has certainly been one of the most controversial amendments in terms of how you interpret that. And of course, it is stated that a well-regulated militia being necessary to the security of a free state, the right of the people to keep and bear arms shall not be infringed. And this, of course, has come under intense scrutiny, especially in the last 10 years. Now, one thing that's very interesting about the Second Amendment is that it is not selectively incorporated. Selective incorporation comes out of the 14th Amendment and basically applies a specific provision or an entire amendment to pertain to all 50 states. If you recall, the Bill of Rights was originally set up to only pertain to the federal government. It was assumed by the Founding Fathers that the states would have already enabled these protections in their own state constitutions. So when cases involved any of the 10 amendments originally, they did not pertain to the states, and that over time they had to be selectively incorporated. Now, a lot of our amendments are selectively incorporated to pertain to all 50 states. However, the Second Amendment is not selectively incorporated up to this point. Now, also some other important background is that there was another case in 2008, just 2 years prior, known as the District of Columbia versus Heller. And in this case, the Supreme Court struck down a handgun ban in the District of Columbia, where, of course, our nation's capital is there. But the problem became, does this ruling apply to state and local governments since D.C. is not a state? So here comes our next case. Now, in Chicago, this handgun ban goes all the way back to 1982, and the whole idea was to reduce crime and violence. There had been a lot of gun violence, and still is a lot of gun violence in Chicago. Now, if you wanted to have a handgun, registration was so cumbersome and complex that essentially it prevented most Chicago citizens from owning a handgun. That's how many hoops and hurdles there were. And residents claimed that this regulation violated their 14th Amendment right with respect to the Second Amendment. Remember, the 14th Amendment would selectively incorporate the Second Amendment to pertain to the state and local governments. Remember, at this point, the 14th Amendment did not apply the Second Amendment. So again, it was not selectively incorporated. The Second Amendment only pertained to the federal government. So the decision comes to a 5-4 decision against the handgun ban. So they do rule in favor of McDonald and strike down that Chicago handgun ban. And SCOTUS is going to rule that the Second Amendment is legitimate for self-defense and is thus applicable under the 14th Amendment. So it's actually now going to selectively incorporate this amendment to state and local governments. Now, it's important to note that the justices are going to write in the majority opinion that certainly reasonable gun restrictions should remain, such as, if you are, a felon, you shouldn't own a gun, or the fact that you should not be allowed to carry a gun on school property. Those, restrictions should remain. However, that is actually technically not law, since not all 5 justices agreed to that part, but that, of course, is going to be recommended by some of the justices who sign off in the majority opinion. But again, the big takeaway here is that the Second Amendment is going to be incorporated, meaning that all 50 states have to abide by this decision and essentially, not have such regulations and restrictions on such handguns. Now, the dissenting opinion is going to argue, and of course this is not the law, but the justices in the dissenting opinion are going to argue that the Second Amendment was never enacted to protect against the state and local governments, that it was only enacted to protect against the federal government, which is partially true. However, with this decision, it is now going to be pertaining to the state and local governments. And some other justices are also going to be arguing in the dissenting opinion as well that there is nothing fundamental about this right. And you can see sometimes this comes down to a liberal versus conservative interpretation. But the big takeaway that the AP Gov people want you to know is that protections of the Bill of Rights have been selectively incorporated by way of the 14th Amendment's Due Process Clause to prevent state infringement of basic liberties. And one of these basic liberties, according to the Supreme Court, in this case, is the right to own a weapon, in this case, a handgun. So at the end of the day, the Second Amendment right to keep and bear arms for self-defense is applicable to the states.